It's a sunny Friday.
And we're live.
Too much happiness.
Yeah, no, then we can all go home and be cranky, right? So let's welcome everyone. It's April 26th, and this is Senate Health and Welfare. We're looking at H121 and about consumer privacy. John, thank you for being with us again. We've asked for some information regarding HIPAA and walking through some of the HIPAA language. And so you're going to have to direct us to a page or set of information.
Yep. So good morning and happy Friday. John Gray, Office of Legislative Counsel. I'm going to pull up on screen in just a moment, but where you're going to want to look for your HIPAA related exemption is on page 16. Page 16.
Are we on draft 4.1?
Yeah, still the same draft as that.
Yeah, I threw all those other ones out. I recycled them.
And I've got it up on the screen in the event that you guys want to look there. So this chapter does not apply to, and we're looking at Division 2 on line 14, protected health information that a covered entity or business associate processes in accordance with, or documents that those entities create for purposes of complying with HIPAA. So just to call out, this is a data level exemption. This is specific to that protected health information. It does not exempt covered entities or business associates as a whole from the Act. And just to call out what those entities are. So under HIPAA, these are recognized terms. Covered entities are folks like health plans, healthcare clearinghouses, and healthcare providers that are conducting certain healthcare transactions electronically. Business associates are the folks who are under contract with those entities to provide certain healthcare, certain services that relate to protected health information.
So in sort of lay language that we can understand, what does that mean for a covered entity?
Yeah. So under this act, as long as a hospital, a typical covered entity here, is complying with HIPAA as relates to protected health information, which is individually identifiable health information, which includes things like your address, demographic information, as long as it's related to those health pieces. As long as those hospitals or other entities are complying with HIPAA, they are not subject to this act with respect to that kind of information. Now, if they're dealing with other kinds of information that are not health information, they are subject to this act. One important piece to call out, though, is this does say processed in accordance with, as opposed to something like subject to. And the reason that I bring this up is to the extent that a hospital has protected health information, but they do something that's not compliant with HIPAA, they would be subject to both HIPAA with respect to that protected health information and to the Vermont Data Privacy Act under this language, because the language is processed in accordance with, right? So it's a very narrowly crafted exemption. You could change this to something like protected health information that those entities process subject to, and that might give some flexibility to treat protected health information exclusively under HIPAA and not under this act. I want to pause there if there are questions about that piece.
Go ahead.
Yeah, so maybe you already explained this, but if they're subject to both, what is the additional things they have to do on top of HIPAA?
There's nothing they have to do on top of HIPAA or information that is regulated by HIPAA. So there's nothing they have to do on top of HIPAA. That's the idea behind this, is that for anything that would be treated under HIPAA, if it's done in accordance with HIPAA, it is not subject to this act.
It's everything, anything else that these entities would be doing that's not subject to HIPAA,
Exactly.
they would have to follow the act.
Yes, and
Can you give us an example of the?
something that might not be in that category. So I think if you look at the memo that was received from the healthcare industry on this piece, I think they talk about things like vendor data or certain volunteer records might be something that aren't treated under HIPAA, that aren't protected health information, and therefore would be subject to this act, but are not treated under HIPAA. So the idea is to not have overlapping protections, but I do want to call out what is an important point on this is if folks are saying, well, we do have some things that are protected health information that are regulated under HIPAA, and then we have other kinds of information that are important to our healthcare services, but aren't regulated under HIPAA. And we don't have to deal with competing or different privacy regimes issuing different notices. I will direct your attention to, and I'm going to scroll down on page 18, line 4. This is your kind of bucket for intermingled data that relates to your health exemptions. So information that originates from, that is intermingled so as to be indistinguishable from, or that is treated in the same manner as information described in subdivisions 2 through 7, 2 being the HIPAA exemption, that a covered entity, business associate, or a qualified service organization program creates, collects, processes, use, or maintains in the same manner as is required under those laws, regulations, and guidelines. Those would be exempt. So the reason I draw your attention to this gives organizations the option to treat information that they have that would not be protected health information under HIPAA in the same way that they treat their protected health information under HIPAA. So they would have the choice to either comply with the Vermont Data Privacy Act under this subdivision, or they could say, well, what we're familiar with is HIPAA. And so we want to comply with HIPAA on this piece. That's the theoretical idea behind this piece. I will say, I don't know whether you can just say that HIPAA protections apply to non-protected health information, right? It could be that protections are specific to ways to treat health-related data, but that if you're dealing with vendor data, maybe HIPAA doesn't speak to that, and effectively there is no restriction in place. But the idea here is to say, we don't want to duplicate regulatory regimes for you. So you get to choose. Do you want to treat everything that you have under HIPAA? We want to make sure that nothing falls out. We want to make sure everything's captured under some regimes, either the VDPA, Vermont Data Privacy Act, or HIPAA. Or do you want to just have everything in HIPAA? It's at their election. But as far as to return to just the question of duplication, this doesn't apply to any protected health information that those entities are processing in accordance with HIPAA, and that's the reason that it's drafted that way. So it is meant to be as narrowly crafted as you can be. But I do want to say the subject to point, which I know wasn't raised in the memo, is an important piece because I could see an argument saying, well, what if we make a mistake and a hospital makes a mistake, they haven't done something in accordance with HIPAA, and because they made that mistake, they expect enforcement under HIPAA, but they would also be subject to enforcement under the Data Privacy Act because of that in accordance with language process and accordance with publication.
Don't make a mistake. Okay, so questions committee, ask questions that will help you understand as much as you need this section. I don't have a question, but understanding of this is really important.
I thought it was well explained,
Yeah.
so I actually do get it.
You got it. All right.
Can you repeat it?
Yes, but I'm not.
No. We can record it on the the question is, well, I do have a question, and that is, under HIPAA, who's excluded here? Where are the exclusions? So if you have a clinic, or you're an independent provider, you have staff, or you have a hospital, or another institution-related medical institution, who, can you give us a list of who's included and who's excluded, or where the other subject matter kind of
Sure. So
intersects?
I don't know that I can give a great answer to this. I do have a summary with me, but I wanted to address maybe the premise of this question, which is the proposed entity level exemption that you guys are seeing uses covered entity and business associate as the requested entity exemptions. So in a sense, this question doesn't matter in a way because they are tied exclusively to what's going to be a regulated entity under HIPAA. So I hope that that helps address it. I can try to talk about what's a covered entity under HIPAA if you would like to know that, but because the proposed entity level exemption matches the same referenced entities in the data level exemption, you're talking about the same categories in both cases. It's just whether or not you're saying our exemption is tied to those institutions as a whole, or whether it's tied to their ability to process data under HIPAA, and that's what the current draft copy was.
Okay,
Covered entities, if you'd like, so health plans, health, dental, vision, prescription drug insurers, healthcare providers could be, it's only for particular transactions, so, claims, benefit eligibility inquiries, referral authorization requests. Healthcare providers include hospitals, non-institutional providers, such as physicians, dentists, and other practitioners, as defined by Medicare, and this part's super important and broad, any other person or organization that furnishes bills or is paid for healthcare. That would be a healthcare provider to the extent they are electronically transmitting health information in connection with those transactions, they would be a covered entity and picked up by both exemptions.
so if there's a private, practice psychologist who is not paid by Medicaid, but is paid out of pocket, how are they covered in the bill?
I think that they are a covered entity as a provider of healthcare, assuming that they electronically transmit those healthcare
Data.
transactions. Yeah, exactly. Now, if they're doing everything non-electronically, then they're not subject to this. But I think that that would fit.
That's
Maybe-
fine, we probably won't find too many of those today. Any other, go ahead.
I'm still forming, are you staying here for the?
I wasn't sure what this question is.
When we,
Are
because I
you
sit
still
hearing
up?
testimony
Yeah.
about what these people in the room want.
Oh, I can
Well, we
sit,
So
will.
are you gonna be here in case I have questions for you after I hear what they want?
I can stay if you would like. I think that's what you're requesting. I mean, they may
Yes,
have a perception
that's what
that
I'm
it
asking.
duplicates things that I don't see, but the idea is certainly not to have any redundancy. So I can stick around.
Thank you.
Yeah, so we don't have people on for today.
Oh, we
have
don't.
not
Oh,
had
okay.
For next week, but they're in the room, and so it might be helpful to get into that conversation we sometimes get into and hear folks' comments. I think it would be helpful to go through this little HIPAA section together, to go through that section of the bill. And if you don't mind walking us through at a, 1,000-foot level, not the 10,000, but.
Sorry, the, not the exemptions, but the consumer health data section?
Yes.
Okay, I will jump to that. That's section 2426, which I will give you a page number in. We're
And
on-
then I'm also gonna, committee, we did look at that section regarding biometric data, the other day. Biometric data, the 4A, where it does not include a physical photograph, audio or video recording, any other data, generated from a digital or physical photograph, audio, video. So I have concerns about that being left out. Just wanted to bring that up now. I guess I'll keep on the road.
You want to come back to that after? Okay. Before we jump into this, and we're on page 50, I did want to note that the proposed exemption we have, this HIPAA data level exemption,
What
is
page
one,
is this?
we're on page 50 for the confidentiality. The proposed exemption that we just talked about is what's in place in Oregon, so this would not be a first in the nation approach to this. The piece of it that is not in place, I believe, in Oregon is the information treated in the same manner as, so there is an attempt to accommodate and provide more flexibility under that intermingled piece.
Okay.
So 2426, section 2426, line 6 on page 50, confidentiality of consumer health data. This, just to call back to, we talked about thresholds last time, who's subject to this act. And we noted that generally for the act, certain numerical thresholds have to be met beyond someone who is just providing services or targeting things to Vermonters or conducting business in Vermont, that they had to process, 25,000 Vermonters' personal data or derive a certain amount of revenue, 50%, to be subject to this. The consumer health protections don't have those thresholds in place. So this applies to anyone conducting business in Vermont or targeting products or services to Vermonters, irrespective of numerical threshold. So just want to remind you of that. So this is pretty brief. It's just setting out a set of heightened restrictions for the health data that no person shall, no person being someone meeting those targeting to Vermonters piece, provide any employer or contractor with access to consumer health data unless subject to a contractual or statutory duty of confidentiality. Provide any processor with access to consumer health data unless that person and the processor comply with section 2421. Section 2421 is your processor duties or processor section, which sets out the requirements of contracts between those entities. The reason that that has to be called out here again is that because we don't have the numerical thresholds in place for this section, you could have folks who are otherwise not subject to that 2421 piece. And given that this is just tied to how consumer health data is handled generally, whether controlled, processed, whatever the term is used, this is a way of just saying we're going to have those same restrictions in place. Confidentiality, you have to treat this in the manner under instruction, you have to comply with those sets of protections. 3, no person shall use a geofence to establish a virtual boundary that is within 1850 feet of any healthcare facility, mental health facility, or reproductive or sexual health facility for the purpose of, so it is for particular purposes, identifying, tracking, collecting data from, or sending any notification to a consumer regarding that consumer's consumer health data. We talked, and I can pause to it.
I'm sorry, I just was thinking about the geofencing. Why else would you geofence other than identifying, tracking, collecting data? I mean, is there,
So
or are we just, this is just for specificity and clarity?
no, I mean, it is for specificity, but it is a good question as to why, I don't know what other sorts of things you would do.
Right.
So I don't have a good answer to that.
Spelling it out, yeah.
Yeah.
All right, thank you.
Well, but it's actually taking the data and then communicating with the consumer. Yeah,
I mean,
it's like, it could be. You could be taking the data, you could be selling the data, and then someone else could send it to the consumer.
Sure, the purposes are, and of course, that would be picked up by the collecting data from, so
Yeah.
that would, but the purposes are just meant to make sure that the prohibition is narrowly crafted, as narrowly crafted as possible, so people aren't confused as to, I mean, I don't know what, I honestly don't know how geofencing works, so I can't speak to what other sorts of things people are doing, but there is a reason to make it narrower rather than broader, rather than just say, hey, no geofences. Perhaps law enforcement or other, there may be technological practices in place that establish virtual boundaries. I'm just gonna stop talking because I don't know enough. Things to-
Find out.
Well, I mean, I think your point, or what I would take from your point is that one could stop just after you can't do this at one of these.
Yeah, that's
facilities
kind of what I.
For any purpose.
That's where I was going.
Yeah.
The,
Mark that,
I did.
the piece I was gonna call out is the references to healthcare facility, mental health facility, or reproductive or sexual health facility. I think we talked about this last time, but I believe that both mental health facility and reproductive and sexual health facility, which had those arbitrary thresholds, would already be picked up by the definition of healthcare facility.
Yeah.
So you may not need these additional call outs.
I think it's good.
Nice to call it out.
Yeah, let's leave those.
Yeah, I mean, there was a reason this,
Including, how about, yes, that's a
They
good way.
can be called any
Yeah.
help without suggesting
Including.
they're outside of the definition.
Thank you, yeah, good.
okay. And no person shall, and this is line 19, sell or offer to sell consumer health data without first obtaining consumer consent. So requiring opt-in for sale of consumer health data. And that's the entirety of the confidentiality of consumer health data section, fairly small, tight, meant to be confined to particular kinds of heightened risks in this context. But of course, if you guys want to contemplate other sorts of issues, you could consider it here, and I can try to help identify if it is already picked up elsewhere in the act, if you have
I'm trying to think about what other, so this is modeled mostly on Connecticut, there's a little bit of Oregon in here. What do other states do in this section?
So the health data piece is a newer piece. It wasn't part of the original wave of comprehensive data privacy regime protections. I think honestly, I've not kept up with the passage in the last month because obviously new comprehensive bills passed in the last month.
We got a little
In other
busy.
states, but this is fairly standard. I mean, Connecticut was the first to do this. I think in Colorado, I think Colorado does some of this as well. But I think that the memo you received also has a couple points on some of the approaches taken in other states, and I'm sure that they can speak to those pieces as well. Maybe not so much on the consumer health data piece, but on the exception piece.
I guess the question is, what would be helpful, I think, at this point is perhaps just on the sections that we're talking about. To hear from the folks who are in the room, because we're on the fast track with this bill, and so we can maybe get some information. And then we can move on to the biometrics, and then I also want to move on to PRA, private right of action.
Can I ask
Yes.
a question
Oh, yeah.
that makes? So we brought up the last time we were in here and Senator Felix brought up the apps that are used that people who menstruate use to track their periods. And I'm sure there are other similar types of apps. Is there anything in here that would
Include those.
protect, essentially having the company that runs the apps prevent them from saving the data on individual
Or tracking.
users?
So the way that this works, we've talked about the requiring opt-in for processing of sensitive data. So that would be the first piece that kicks in for protections, is that you're talking about consumer health data. So they're going to have to obtain consent to be able to, the app will need to obtain consent to do that. As far as collecting, controllers will need to, there is a data minimization principle built in. And we talked about this last time at a super high level, just to say that the data can only be used for disclosed purposes, so purposes that the consumer is going to be aware of, and then they have to limit to what is reasonably necessary and proportionate to those purposes. So if what they disclose is, this is going to be to provide you the services that you're asking for on the basis of your tracking, like you want to know when this is happening, but it doesn't say that they can sell that data to somebody else, right? And we just saw in this section, that there's a prohibition on selling without consent. So they would have to obtain consent for that sell. They would have to obtain consent to process that kind of data, and they would need to disclose any purposes that relate to how they're using that data. So I hope that,
Yeah,
So you're leaving it up to when you download the app and you put it on your iPhone or your wristwatch or whatever, then there's the opt-out or the
in this case,
opt-in.
it's an opt-in.
It's an opt-in for this one. So are there any directions for how visible that is upfront and how much it?
Well, that was my question.
Yeah.
Is the opt-in like a 20-page privacy manual agreement?
I agree, I disagree.
That is.
So let me pull up screen share again, because we do have pieces related to this, although it may be that there are practical limitations to how effectively this can be done with the amount of information folks have to disclose in a privacy notice. We do have restrictions. Like it just is a lot of information. Let me, I think this is in 2419. We have requirements for how the privacy notice is meant to be framed. So we'll be starting on page 8.
Should be just like. Essentially, clear.
we can use and sell your data.
Exactly.
Like here.
That's what I want. That's what I want to see.
So I will just say there are standards for visibility and design of the disclosures. As far as the privacy notice will set out a set of features, and then the opt-in will be something beyond that, right? That's not going to be contained in the privacy notice necessarily. It's going to be a separate piece that has to be done. I think when we spell out these, and I'm on page 30, we say that a controller shall provide to consumer a reasonably accessible, clear, and meaningful privacy notice. And then this lists a bunch of things that have to be set out there. But we go on to say that that privacy notice has to adhere to accessibility and usability guidelines, including ensuring readability. I will just say, because this is bringing to mind, this is specific to the privacy notice and doesn't apply to all instances of disclosure that would occur under this act. So if you wanted to boost something out for how
Yes,
consent is secured, I might, think about where to put that. And it might be easy to put it in the 2418 consumer rights A6 or something like that, but I think there's a way to do that if you want to target it specifically to just the securing consent piece. And you could do something similar to this, like adhering to accessibility and usability guidelines, including ensuring readability, although that's a bit different than just concision. And, I do think we have pieces in here that say you're meant to ensure, like, the methods used to secure data, so the things that controllers are receiving benefits from are meant to be essentially no easier than the points that advantage consumers. And there might be a way to have an easy line to that effect that applies to the whole bill to say, any methods used under this act to obtain consent or do pieces have to be as easy as methods for the controller to obtain the consumer's data, something like that, just to tie them together. So,
so we're at a place where we can say, yes, we want to do this, so.
Yeah, I
I think
think,
we do want to do something here.
I think it needs to be clear when somebody's giving their consent to the data, for their data, I think it needs to, I would like to do that. The one problem is that even after, I think it's hard when you're downloading an app thinking, oh, I'm gonna do this thing.
And you agree to everything.
And it's hard to know the implications of what that means.
Oh,
You know what I mean?
yes, so,
Especially, I'm thinking like a, 14-year-old girl who might be downloading this app to track her period, and she has no idea that pressing I consent means that this company keeps
Okay.
all this data on her.
so I may have some happy answers as to existing pieces of the bill that address this.
Okay.
One is what consent is. This is on page 3, starting on line 7. And I'm sorry, we're jumping
No.
30 pages at a time. So consent is a pretty built out concept here. So a clear affirmative act signifying consumers freely given specific thing, a keyword here. It's not a general consent to any list of things, that it has to be to the particular processing. So clear affirmative act signifying to consumers freely given specific, informed, and unambiguous agreement to allow the processing of personal data. May include a written statement included by electronic means. And it does not include, and this is exactly to your point, acceptance of a general or broad terms of use or similar document that contains descriptions of personal data processing along with other unrelated information, hovering over, muting, pausing, or closing a given piece of content, or can obtained through the use of dark patterns. Dark patterns or ways of securing consent essentially through deception, and the FTC has defined terms for what constitute dark patterns, but it's things like fake boxes that you can click on or ways of kind of glitching through to obtain your consent. So I think that this might actually address some of your
Yeah.
concern here, is that this is meant to, I think the specific piece is really important here. You are consenting to a particular kind of processing. It can't be hidden, and you can't just have it in this huge document that has all kinds of other information. And you actually have to take affirmative steps to do it. It is not, just appears on the screen, you exit out.
Well, and so one of the concerns that I have, and it relates to what Senator Hardy was just mentioning, is that sometimes these things are just embedded in a whole stream of information.
Mhm.
And so it might be,
Yeah, this is meant to avoid that
you
kind of,
wanna avoid that,
Yep.
right? You agree to the terms of conditions. And so this will avoid that problem.
Yep.
Okay.
Sorry, what about, so my example involved a 14-year-old girl, which is, she's a minor, so in that instance, are there higher protections for?
there are higher protections for minors, so because this would be sensitive data. At 14 is actually an interesting, so if it's under 13, parental consent would be required in alignment with COPPA, Children's Online Privacy. For 14, the child would be in the position to provide their own consent. So I guess that's my entire response to that is that they would have these methods available, the consent methods available here that are meant to cabin how coercive or deceptive the mechanisms for securing consent could be, but it would be in the hands of that minor to determine whether or not they did consent. There's nothing to say for that kind of special like consumer health data that with someone who's a minor, they have to let me scroll to the section. Sorry, there are just so many.
No,
Let's go to 2420, starting on page 34.
Amazing you can remember all.
I know.
Duties of controllers to minors, what's? like what we're
Yes,
talking
yes,
about.
yep.
Mhm.
That's what I wanted to jump to, because we do have some pieces here that apply to that 13 to 16 age gap. So controller offering any online service, products, feature to consumer whom the controller knows, and that's important, they have to know, is a minor, they have to use reasonable care to avoid heightened risk of harm to the minors. That is a defined term, if we can jump to, if you would love to see it. But I wanted to jump down to this piece, unless controllers obtain consent. A controller that offers any online service, product, or feature, the controller knows as a minor shall not process for these heightened purposes. Let me jump to the, sorry, we're on page 35. I want to get to the 13, 16 if I can find it.
No, it's amazing.
So there is a reason that this kind of restrictive mental state is used. If you make this strict liability, in essence, you would have to have age checks at websites to confirm who's coming. So it is intentionally done to, we're kind of limited in what we can do, and that's why a mental state is used here. We I think it's kind of on the 14-year-old to determine. I did want to just call out this section, and I'm happy to go through the section if you guys would like to see what enhanced protections are in place for these minors. So we have to obtain consent for, just to contrast what's done for minors with what's done for consumers generally. For this first piece on line 15, obtaining consent for processing that minor's personal data for targeted advertising, sale, or profiling for solely automated decisions. For consumers, generally, this is an opt-out, so it assumes that businesses are operating this way. Different presumption in the minor context, they have to secure consent to do these things. Imposes similar data minimization principles for minors, but says only for processing purposes disclosed at the time the controller collected that minor's personal data, or one that is reasonably necessary for and compatible with those purposes. I think this one it's not directly responsive to the point about like, will the 14-year-old be adequately informed, which is maybe a bit beyond the scope of this, at least currently, but it does have limitations on how long that data can be collected. So here you see on line 6, processing a minor's personal data for longer than is reasonably necessary. They are confined to processing only as necessary to provide that online service, product, or feature. So if they're using the app to track, it's not as when the minor is not using it, which I don't know practically how that works. It may be that it's always running, so it's regularly running, but they would be limited durationally as to how they could use that information. Or is it really relevant in this context? And there are restrictions on precise geolocation data for minors, but I'm afraid I'm going a bit far afield of this, and I think the answer is the 14-year-old has to provide consent, but it is up to them as to whether or not they provide it.
Okay.
It's hard to do anything else, but.
I mean, you could say that, this is an area in the minor protections piece where you say for special kinds of data like consumer health data, that some kind of enhanced. I don't know if you want to get into enhanced disclosures, but just because that's the topic that kind of led to this. You could try to set up the opt-in consent for this to have some additional guardrails if you wanted to. I haven't thought about how that would happen, but that's something you could attempt to do here is.
No, it's worth thinking about, let's do this, unless there's another question here, we could think about having some enhanced opt-in regarding health care information. You know how to do that better than we might have.
I
Well,
hope.
Yeah.
Jake, where was the section on what,
So the consumer health,
well, no, what defines
Previous section.
consumer health data?
so that's at the definition
Here,
2415, it's probably
Okay,
like
it's in that
page 30.
definition, cause I'm just thinking of like all the just various apps, I mean, clearly like a period tracker is, but is also, you know, the apps that count how many steps you walk and all those kinds of
Yeah.
things.
Heart rate.
The heart rate
And-
apps,
Yeah.
the, you know, there's so many of them.
And I should say, just as a philosophical point, because obviously we, get into the rooms and we're discussing privacy, and so all the focus is on protecting privacy, which is, that's the point of the bill, but it is to say that consumers can choose, like, consumers get to choose whether they want to. Plenty of consumers are gonna say, I actually do receive benefits from exchanging my personal data for certain things, I like having my information tracked so that I know my health, like, this is meant to grant people the option to do that, so it is. We can certainly establish more safeguards, but this is meant to preserve consumer autonomy in the space as well. I just wanna
Yeah.
note that, just because all the conversation becomes about increasing protection, which is, you guys' call, but just. There is a reason it's set up to be both largely an opt-out regime and to preserve consumer flexibility.
In regard to 14-year-olds, parents still can control for electronic devices, cell phones and iPads, they can still block what their children can have access to.
Yeah, so this act doesn't do anything to disrupt or address that particular piece. It does recognize that it has built-in age differences like the one that we just talked about between those under 13, between 13 and 18, recognizing that at a certain point, children are approaching adulthood and are regularly interacting with technology and making decisions there. And so it doesn't do anything to disrupt or change that piece, but it does say that for those 13 and older, they will be providing their own consent.
Do you have a comparison side by side or something, the House versus this version?
I don't at this point. I can do that for you by next week if you guys need
Oh,
that.
that's a lot of work, I'm not.
I mean, I can
Do that, but I'm just curious.
I can call out
What-
big pieces that are easy to call out as differences. One is obviously the removal of the private right of action.
Yeah,
In the House version, previous sections 24, 23, and 24, 24 were sets of data protection assessments. These were things that required controllers to conduct an analysis of particular processing they did that had heightened risk. To preserve those data protection assessments so they have them on hand and can be turned over to the AG if there's an investigation. In the minor specific data protection assessment fees, which was 24, 24 in the House version, not this one. There was also a requirement that if particular kinds of processing were deemed to create, or that there would have to be a process of regular review over time to see if any changes to the online service or product feature offered was presenting a new risk to minors. They would have to review that regularly, and then they would have to actually come up with a plan to mitigate that risk. So there were, I would say those are three, the data protection assessments and private right of actions are big differences here. Obviously, some of the definitions have changed as well, but that's a bit more in the weeds to go into as far as like large sectional changes. And then the currently we have, and we hinted at this last time, the AI Council dealing with enforcement oversight and potentially development of publication, public outreach, education, and in the future, potentially a private right of action. That replaced what was in the House as a section that was just specific to tasking the AG and potentially ACCD as well with developing public education and outreach. And then did not have an oversight of the AG's piece. Should get into questions there as to. So I can give a more detailed next week if you need it, but those are big differences between the two.
Yeah, I know the PRA was a big one.
And also the threshold and as.
Yeah, the thresholds changed, went from, we talked about this last time.
Yeah.
What was 6,250, so 1% to 25,000. And then the revenue generating piece was 3,250 or 0.5%. Vermonters plus derived at least 20% of revenue, that switched to 50% revenue, but no numerical threshold. Other concepts, I won't go into the details just because it's gonna be confusing, but concepts to pay attention to that are different between the two. Targeted advertising, has different definitions here. We had enhanced, I said, the House had, enhanced requirements for targeted advertising to minors. That prohibited first party advertising, so essentially no kinds of direct targeted advertising to minors. The data minimization principle in the House version was different. That's at 2419A1, if you look in the House version, and it was tied to, I don't want to go into the weeds, but those data minimization principle at 2419A1, targeted advertising, glad you brought up thresholds.
Targeted advertising, where is that in the?
So the definitions, so targeted advertising is something that,
So just at the highest level, the targeted advertising is prohibited where, for, or not. So,
targeted
yeah,
advertising,
well, we're trying to drift into what economic development is
Yes.
responsible for, and I don't want us to go too far. We do understand we don't want targeted advertising regarding healthcare information. So if you could just give us globally, what would this do for healthcare information being accessed and then used for?
yep. So the principle in this bill, and also in the House version was that you opt out of targeted advertising, so it is possible for controllers to engage in targeted advertising. It just needs to be a disclosed purpose. Excuse me, I will say in the House version, there was a data minimization principle that was tied to services. I don't want to go into too much detail, just you guys don't have the background to get, but there's an argument that in the House version, targeted advertising required opt-in, and I think that's a fairly strong argument. So that is what the House version did, in this.
So let me ask this question. I know Senator Lewis has the question as well, but can we separate out healthcare data as a for that target?
So I should say, I'm just talking about targeted advertising broadly, because consumer health data is a kind of sensitive data. Targeted advertising would be a kind of processing and therefore would require opt-in. So I think in either case, you have higher protections for consumer health data already built in both versions, House and Senate.
Okay, that's good.
Yep.
I actually have a comment, which is that, sorry, we were drifting, so I figured I'd go with the drift, but this bill for me underscores and underlines the need in the Senate to have a technology committee. Because I feel like each of these sections could be their own universe.
Mhm.
And I mean, it's a 74-page bill, and I feel like we're just scratching the surface. So I do hope whoever's listening that someday we have a committee that can address this full panoply, because I'm also thinking in my educator hat is like, what are we teaching kids? Like, what's happening there? So it's just like, anyway,
It's big.
made my
It's
comment.
huge. Good comment.
Thank you.
From a ledge council perspective, it'd be cool to staff a technology.
Okay, well, we could write that into the bill. That's not appropriated.
Well, can you appropriate some funds,
Yeah.
to me,
I know we've got people in the room we do need to hear from, but, this, you can see why we had this level of conversation for an hour today, because it's very helpful to us. I want to ask a question about the drift another place, and that is to the biometric,
yes.
section. Where the exclusion, not including
Yes,
this one,
we're on page 2
yeah.
and 3. Yes, so that's the difference between the House and Senate versions. In this version that you have from economic development, biometric data specifically excludes digital or physical photographs, audio or video recordings, or any data generated from those photograph or recordings unless generated to identify a specific individual. the reason that Center Economic Development took this approach was that they didn't want photographs that aren't used to generate identify a specific individual, because photographs taken broadly of someone that to be picked up as sensitive data and therefore require opt-in consent. So that's the approach that they took there.
Can you explain that again?
Yeah, so biometric data, just to orient, this is again another kind of sensitive data, so we're talking about opting in for processing. It is important to talk through this first section here, the definition, and not just the list. Personal data generated from technological processing of an individual's unique biological, physical, or physiological characteristics that is linked or reasonably linkable to an individual. So that's using technology to capture those unique characteristics that could be used to link or identify them. You could see an argument that a photograph is exactly this kind of, it's a technological processing that displays a person's unique characteristics and is obviously linkable to them. It's them. So to make that sensitive data, which biometric data gets put in sensitive data, you will need opt-in consent for that kind of processing. So the goal was to ensure that you aren't accidentally picking up photographs. I should say, again, we're talking about in the context of an act that's only applying to particular sets of entities. This isn't you or I taking a picture of someone and it accidentally gets picked up. That's not what this is about. This is an entity that's subject to this act. And the example that we were always given was a ski resort that has photographs of folks on the mountains. They've taken this, it can be used to identify someone. Now, since the data, did they need to secure the consent of the folks who they took the picture of, something to that effect.
Would that include a driver's license?
So driver's license, I think is independently a kind of sensitive data, so it might be helpful to scroll down to that definition, and we're on page 13. The first one reveals a consumer's government issued identifier. So a driver's license will be picked up by sensitive data, whether or not it is picked up by biometric data.
So, go ahead.
Bringing it back to menstruation again. Is that's not a biometric data point, that's more of like a bodily function or?
So I think there's let me scroll back up. Personal data generated from technological processing of their unique characteristics that is linked or reasonably linkable. So I think the key question is probably the linked or reasonably linkable. And that that's an empirical question,
We'd
but if
have
it
to have
was,
some
then yes.
data entry to have the link.
I will say that we include this list of items to spell out, to deem things to definitively meet the definition of biometric data. It's nice to do this because we can say definitively that these are the ones that count. There's always a worry that if you don't include things in a list, even though it's not exhaustive, that it might have some kind of negative implication that others are therefore excluded. But I think it's fair to read that the concept here contained in lines 7 through 10 could capture that theoretically. It doesn't, part of the difficulty I struggle with and why I bring up the negative implication point is that if you look to those items in subdivisions 1 through 6, I through VI, it feels, I don't know how to explain this better than that, feels a little different to me, and you can see someone saying, oh, this isn't biometric data on that basis. But because you're already picking it up elsewhere as a kind of sensitive data, I'm not sure that you have to have that. Like the protections that are extended to biometric data are the same protections that are extended to any kind of sensitive data generally. So if you're picked up there, I think you're safe.
So when it says voice prints, but down below audio, just taking audio out is excluded. So
That's a good, I think if you wanted to type
so
it
you
out.
are capturing someone who's taking your voice and using it irresponsibly.
Yep, but I think to your point, if we wanted to say an audio or video recording other than a voice print or something like that, if we just wanted to make clear, I think it is clear that voice prints are captured.
Yeah.
But there is a tension between audio recording and voice print, obviously.
Those kinds of things, the fine line is what I think is bothering us here, or at least bothering me. Okay,
Can I ask a
yeah,
question? So the way I understand this is sort of that I highlighted the word unique because so,
Yep.
you know, if I give my fingerprints, that can be linked back to me that, oh, those are Ruth Hardy's fingerprints. But my blood type, which is another type of physical, you know, if I'm, you know, blood type A positive, because I'm being A positive, there are lots of people who are A positive.
Right.
So it's not necessarily, you can't link it back to me.
Right, the
But-
link piece is key here.
Exactly, but my DNA in in a sample of blood could be linked back to me, yeah?
And genetic data is another kind of sensitive data and would pick that up.
That's somewhere else in here?
Yep, we have a
Okay.
definition of genetic data if just a couple pages past this, but genetic data is included in the list of sensitive data, so that would be captured. I did want to call out why the photographs or recordings would be included in the first place, like why did House Commerce opt to include these? I think it relates to businesses that scrape the internet for pictures and
Right.
then use that.
and then use it irresponsibly.
Exactly, so that's why it's included, but there is a legitimate concern that you could accidentally pick up all kinds of permissible action in using that broad category. But genetic data, that's a kind of sensitive data, you'll be good there, and the linking to a person is a key part of biometric data.
Yeah,
If it just
So-
happens to be data about them, but you don't know it's about them, that's not.
right, or that you can't track back to them, like,
Is there a way to clarify the language under the not include? That, as you said before, so the linkage piece. Um. So it's linking with the voice patterns, for example, or the photograph is linking with facial mapping. So is there a way to?
Yes,
to
yes, we can
link
say.
that So there's some clarity there. I think that's helpful, at least it's
Yeah.
helpful for me.
So the request is to make sure that the exclusion in the subdivision B is sufficiently tight to make clear it is not accidentally excluding things that are picked up above.
Yes.
Okay.
Exactly, that would help. And because we're short on time, I wanna bring up. So this is helpful, and I think we'll think about this, but we're gonna think about all the things we've been through today. I do have a specific question regarding private right of action. And it's not in the bill, I guess. And so in our area is healthcare. But I'm interested in reapplying private right of action in some way. So that, and we know the levels, it could be the AG, can be, it's a civil act, and can be the AG. It could be an individual, so. Is it possible we can add private right of action to the sections of our jurisdiction?
Yes. So and I didn't mean to cut you off.
No, that's
Yeah.
fine.
Yeah, so the way that I would probably do, just based on what you guys have talked about in the past 2 days, I would say, you know, folks have the right to, I would say I wouldn't describe this way in legislative language, but folks would have the right to pursue a cause of action for violations of 2419B2. So it's nice to have a specific statutory site so that people aren't having to look through the bill for what kind of violation they're talking about. 2419B2 is your controller shall not process sensitive data without consumer consent. So I think that's a key one we've been talking about. Or for violations of section 2426, which is the consumer health data piece. I think that would really capture the things that we've been talking about here. So private right of action for violations of 2419B2 and 2426. And then I could, come up with language as to how that's spelled out. Obviously, it would not be hard to look back to the House version just to mirror the language that's used there. And if you wanted to, there's all kinds of things you can do with the private right of action. You can set minimum thresholds if you want to, or you can not. You can call out particular kinds of harms to recognize, because a lot of times what you see is, particularly when enforcement action may be informed by FTC practices, certain kinds of harms are not as readily recognized by courts. So it's easy to recognize economic kinds of harms, right? But things like reputational harm,
Right.
which is a key thing for privacy.
Yes,
I think it would be helpful if you want to do a private right of action on these bases to make clear that non-economic kinds of harms could be picked up, like reputational harms and the like, and I don't admittedly know a lot about doing that, but it's something we could try out basically, and I think it's worth spelling out the kinds of harms you want to capture. So if this is something to pursue, I'll definitely email you guys or come back to talk to you about how to boost this.
That would be great, yeah, that would be helpful. At least for me, I'd like to look at it and have the committee look at it would be very helpful. Okay, all right, so let's do that. And then we have someone coming in with an amendment, probably in a minute, a few minutes. Is there anything, we've kind of gone through the things I think the committee has been really interested in, and you've generated a lot of good thinking, ideas, questions. I appreciate the work you're doing. We'll put the technology task force.
Yeah.
We won't do that. Okay, is there anything else that committee you'd like to go through at this point? That we went through the bill, some areas of interest. Any questions?
I mean, we did mention a couple other smaller things too that I think you wrote down too.
Yeah.
To clarify,
What, do you have a list of the things that we've identified?
Yeah, so I can call out and then if I can.
Let's do that.
Yeah,
That's
so
what Senator Harris asked.
in 24-26, whether to prohibit geofencing generally without that particular tie to used to identify, collect, track. I don't know if
Yeah.
that's something you wanted to. I could read my handwriting, which I can't.
And then also at Jen's suggestion on that same paragraph 3.
Yes, including, that's what it is. I
So
just had the
that-
word.
Yeah,
including.
Yeah,
so that
including.
it's clear that they are healthcare
Yes.
facilities,
Yeah.
that, yeah.
For the opt-ins, I think there's requests to maybe have a kind of enhanced opt-in for consumer health data if possible.
Yes,
For biometric to tighten the exclusion to make clear that those overlapping with any of the deemed list of included items, don't accidentally exclude them. And then a priority of action for 24-19B2 and 24-26 that contemplates non-economic.
Yeah.
Anything else that I may have?
And just to be clear, the number of thresholds don't apply to healthcare organizations, right?
To the consumer health data protections and consumer health data controllers, which would presumably be those.
So no matter how small.
That's right.
Yeah.
Those pieces are covered. Okay.
okay,
And I hope that you guys will get to, if there is a perception of the exemption that this does in some way duplicate, which I don't think that it does, but would be happy to talk to folks if that's a continuing point of contention. Okay.
all right, so I know that there are people in the room. I'd like to have Senator Kitchell come in with her amendment 766 so we can look at that. And while Jen is here, but you, I know each of you has a different interest in the bill or some common interest, so if you can stay glued with us as we go through 121. We do have testimony lined up next week. I think it's on Wednesday, because Tuesday looks like it may be a full day on the floor. If we can get to it on Tuesday, Kiki will schedule it in. So just keep your eyes open. We could come back to 121 as early as Tuesday. We will definitely come back to it on Wednesday, and I know the AG is ready to testify and others are ready to testify, so we'll get the information we need. And then do read through the bill and more questions. Okay,
Cool.
all right.
Sounds good.
And so so are you going to structure some language for us before the next time we meet on this? Can you do that?
Do you want to see it in advance of being presented in committee?
Yeah, if you can structure for us, I'd like to, if you can copy me on that, and copy Jen on that, and then if you don't mind. I'm not, I mean, Jen is HIPAA as well, but
Yeah, she's-
probably not as. Okay, but, and do that, and then we'll bring it to the full. That would be helpful.
Okay,
Okay, and then,
and just to confirm, the date for that would be Wednesday for new language.
get it by Tuesday, that'd be great. I can get it to the committee ahead of time, that would be awesome.
Oh, okay, okay.
Yeah, yeah,
That's
That's-
ahead of time is Tuesday to the committee.
Yeah, yeah.
Okay.
yeah, the committee wants this. And if there's something more, we might ask for that as well.
Sounds good.
This is not an easy bill, oh my
Yeah,
gosh,
I'm
yeah.
super
I
impressed
don't know
on
what
how
you're
well
talking
you know
about.
it. It's very
Thank you.
impressive.
Do you want to start, let Senator Fisher, she's on her way,
I'm gonna just warm up my coffee now.
okay, but don't go far.
I will not go far.
Please. Thank you, John, he's great.
Thank you.
Are we going right to 11:30?
No, we're gonna take a break, but
Okay,
I
great.
wanna get Senator Kitchen in here. We've got Katie coming in, and Jen is on a flexible, not a, has a schedule that takes her to the house, so we wanted to do it while the house is on the board. That's so it's scheduled.
Audrey didn't want him to go to that. To get lemons. They got, Chris got lemons. Everything's lemons.
Oh, everybody's up there.
Really,
Sugar.
little, use your app.
I think he's been super flat. Nice. And you, I was surprised at how like when you're